At BLM, we are keen to make sure you understand what is involved if you are ever asked to provide evidence in a case. This includes documents that may be in your possession or a witness statement. Please watch the video which follows to find out more. We also provide further material for you to download, and details will follow at the end of the video. If you have any questions, please do not hesitate to get in touch. Please watch our other videos in the What If series for further information regarding legal know-how for clinicians.
First of all, Sarah and Luke will explain what we mean by the phrase disclosure and how it impacts upon you and your obligations to the court.
Disclosure means formally stating that documents or classes of documents exist or have existed. It is limited to documents which are or have been in the party's possession or control. The purpose of disclosure is to make available evidence which either supports or undermines the respective parties' cases. It allows the court to do justice between the parties with an all cards on the table approach. The parties must carry out a reasonable search for documents, bearing in mind all of the circumstances of the case, the value of the dispute and the overriding objective of dealing with cases justly. A document is defined as anything in which information of any description is recorded. It is a very wide definition which extends to electronic documents, including emails and metadata. It includes materials which is not readily accessible from computer systems. The obligation is to search for and disclose documents currently or formerly in the party's control. Control means physical possession or the right to obtain a document from another party, or the right to inspect or take copies of that document. This does also include those documents that adversely affect either your own or another party's case.
The phrase inspection relates to the process by which a party who has disclosed a document either allows the opponent to view the originals or, more commonly, provides the opponent with copies of documents disclosed. Inspection of documents may be required at the outset and will then be formally confirmed once proceedings have commenced. This requires the completion of a formal court document known as the list of documents, which your legal representative will explain to you. It is how a party sets out the extent of the search for documents, confirms their disclosure obligations, and confirms that they have complied with those obligations. Confidential or privileged documents must be disclosed but may not be inspected. That means that you have to confirm their existence but will then decline to provide the copy to the other side.
The duty of disclosure continues throughout the claim, and it includes the duty to preserve relevant documents. There are consequences for late disclosure which could affect your case. The key point really to take away from this is that you must preserve all disclosable documents and are under a duty not to mislead the court. There are serious consequences in terms of criminal and regulatory sanction should you deliberately conceal information or disclosable documents, and it is strongly recommended that you seek independent legal advice as soon as a request for disclosure or inspection is received.
Next, we will look at witness statements, which are prepared by and for the parties involved in the factual disputes of the claim.
The purpose of a factual witness statement is to set out your factual account. So what do you independently recall? What is your usual practice, and how did you treat the patient? This document will assist the court in identifying the facts on which the case is determined and gives you an opportunity to explain your clinical judgment. It is needed once the claim has started formal proceedings, although it is helpful to have it before in certain cases, for example, when there is a dispute between the patient and the doctor regarding what happened. The statement will usually be drafted by your solicitor following detailed instructions from you. You will have the opportunity to check it and ensure it is accurate and in keeping with your version of events. We do advise that you keep it factual. Attempting to speculate and to give opinions should be kept to a minimum. Avoid emotive language and ensure that you specify what is personal recollection and what is said with reference to the medical records. Include brief details of your experience and role at the time of the incident. Provide a summary of your involvement in the case and the treatment of the patient, as well as how you reached your clinical conclusions.
It is also mandatory for a statement to be accompanied by a signed statement of truth, which is a verification by you that the contents of the document referred to are true.
Finally, we will look at expert evidence, what it is, how it is used, and for that I now hand you back to Sarah.
An explanation of the nature of expert evidence is required in order to understand the important role which experts play in claims brought in clinical negligence. Medical evidence assists the court in defining reasonable standards of medical practice, determining what injury is being caused, if any, as a result of the treatment provided to the claimant, and also determining what treatment, if any, is required to put the claimant back into the position had the negligence not occurred. Medical evidence essentially regulates the proceedings and allows each party to substantiate their case. However, it must be restricted to that which is reasonably required to resolve the proceedings. An expert is a reference to a person who has been instructed to give or prepare expert evidence for the purposes of proceedings. The court must grant permission to a party to rely on expert evidence within the proceedings. In clinical negligence claims, experts are usually commissioned to provide the instructing party with medical evidence which relates to the liability or quantification of damages. Experts will need to be of an appropriate discipline and must only report on matters within their expertise.
It is also important for us to discuss the duty that experts have and their general role in the process. Experts have a duty to assist the court on matters within their expertise. This duty overrides the obligation to the party from whom the experts have received instructions from. When preparing their reports, experts should consider all material facts, including those which might detract from their opinions. Experts should, however, make it clear when a question or issue falls outside their expertise and when they are not able to reach a definitive opinion. If, after producing a report, an expert's view changes on any material matter, that change should be communicated to all parties without delay, and when appropriate, to the court. The report must contain a statement that the expert understands their duty to the court and has complied with that duty.
After reports have been exchanged, the next step is discussions between the experts. The purpose of the discussion is to identify the pertinent issues in the proceedings and, where possible, reach an agreed opinion on those issues. The court may direct that following a discussion between the experts must prepare a statement for the court setting out those issues. The experts must agree to the discussion being referred to at trial. Where the experts reach agreement on an issue during their discussions, the agreement shall not bind the parties unless the parties expressly agree to be bound by the agreement.
And finally, if the claim proceeds to trial, the experts may be required to attend and give oral evidence in support of their opinion. Experts may be required to attend trial to clarify their opinion in order to assist the court with its determination. This is usually achieved by way of questions which are addressed to the experts by either the barristers or the judge. After hearing all of the experts, the judge will determine which evidence he or she prefers, and they will be required to give their reasons why.
We hope you found our video informative. To download further material, please visit the link on the screen now or contact a member of the team. Thank you.